Hi everyone, this is Matt with the Bangerter Law Office, where we defend good people accused of bad things. Today we're going to talk about Miranda rights. I've been practicing criminal law for over 13 years, and of the clients who've called me when they've already been arrested, probably 75% of them would say, the cops didn't read me my rights, does my case get dismissed? So we're going to talk a little bit about what your Miranda rights mean, and then we'll follow up with a little bit of trivia about Ernesto Miranda himself. So we all know the basics of Miranda. We've seen it on plenty of police shows, law enforcement shows. You have the right to remain silent. Anything you can say can and will be used against you in court. You have the right to an attorney. You get a free one if you can't afford one, etc. The point of these is to avoid having an accused make a statement when they don't know that they're entitled to have an attorney with them to talk to the police. But the Miranda rights only apply when you're being questioned by the police and when you are in custody. In custody means basically that you're actually arrested. You can be, and courts view this very narrowly, you can be sitting in the back of a cop car and the courts will say you're not in custody. You can't get out of the cop car, you certainly can't run without getting tackled and tased, but the courts will say you're not in custody, so the Miranda rights don't apply. And you have to be questioned. If you're sitting in the back of the cop car, if you've been arrested even, you're on the way to the station and you start feeling chatty and lay it all out, then the cops can use that against you and it's going to come into the trial against you. Likewise, if you're not in custody, if you're walking in the sidewalk and the police come by and say, hey, did you steal this car, and you start talking and lay it out for them when you're not arrested, then that's coming in too. They're going to use that against you. So it's only in very specific situations that it applies. What happens if it does apply and they didn't read you your rights or advise you your rights? Well, then that statement alone doesn't come into the case. They can't use it in trial against you. Sometimes that can make or break your case if that's the only evidence they have. In most cases, I would say there's enough other evidence that the case can still proceed to trial. But having said that, it's always a possibility that you need to look at for your defense. Anything that can help in trial, any little bit of evidence that can get withheld could help you in trial, so it's definitely worth looking into. So while it's probably best practice for the police to advise you of your rights in any time that it might apply, they don't necessarily have to. And if they don't, it may not have any effect on the case if they didn't apply to you at that particular time, if you weren't in the back, or if you weren't in custody and you weren't being questioned by the police. Now, as for Ernesto Miranda himself, the fella who went to court and got this case named after him, he was accused of some pretty major crimes. His case actually got reversed in the case of Arizona versus Miranda because he wasn't advised of these rights. His case went back to trial. He was convicted the second time around, was sentenced to a pretty long prison term, but got paroled in the 70s. He enjoyed a little bit of infamy. He used to carry around Miranda warning cards, autographed, and sell them for $1.50 in the 70s. He spent the next few years in and out of court, violating parole, etc., and eventually died after a knife fight in an Arizona bar with a pocket full of autographed Miranda cards. So that's where Miranda comes from, if you didn't know. If you like this video, don't forget to like and subscribe for more. If you want to learn more about criminal law in general, check out my website at www.bangerterlaw.com and download my free ebook.